Can I bring a letter from a witness with me to court? People ask lawyers that question sometimes, and I like advising people of kind of how the law works just to help you have a better understanding of it. And so here's one of the issues with that. Imagine this. Imagine that you're on the other side of this person, whether you're a prosecutor or it's a lawsuit and you're going against them or whatever, and they bring a letter from a witness about some fact of their case against you to court. What would you say about the judge or the jury accepting that letter into evidence? You'd probably say, that's not fair, or we disagree or something, right? And that's one of the main reasons that you can't just bring a letter or even a notarized letter, which is potentially under oath, to court, okay? So people do ask lawyers this question, and I want to tell you why that is. One of the greatest tools to trying to ascertain what the truth is cross-examination, right? And there's stories in American history about cross-examination and how that tool has been used to discover the truth or potentially to catch someone in a lie, if you will. If somebody brings, if you have a case going on and you bring a letter with you from a friend or even a witness that you didn't know very well saying, here's what I saw this day or didn't see, or here's what I heard or whatever, right? The other side doesn't have any opportunity to ask any questions of that witness that they'd like to because the person isn't there. So you're only hearing one side of the story, and you can't, even if that person's telling the truth from what they're seeing, you still wouldn't be able to point out, for example, some things that they may not have seen, or that they only came to the scene after a certain amount of time and didn't see what happened before that, or any other facts that you'd like to add in to complete the story, if you will, or prove your point in the case. And so for that reason, in the vast majority of court cases, including criminal cases, of course, you can't just bring a letter from someone instead of them coming to court and use that as a substitute for the person coming to court, all right? Once in a while, letters can be used in court for other things, such as if you've pled guilty or you've been found guilty at trial and you're going to have a sentencing hearing later, you can and should get support letters from people that know you well and can talk about other good things about you to give the judge a better picture of who you are rather than just that moment in time where your case went on. And that judges do appreciate the benefit of having that, and I think a good lawyer does help their clients to round up letters from supportive people that we then will give as a packet to the judge so the judge has a better idea of what kind of person you are instead of just perhaps this not-so-pretty situation where you may have committed a crime or pled guilty to a crime, okay? But for trials or other hearings in court, if you will, the vast majority of the time a letter is not permissible because there's no opportunity for the other side to cross-examine them. I hope you found this video helpful for you. If you have questions about the law or find it helpful, you can always find me. You can like the video, of course. You can subscribe to my channel, and you can share it with other people as well. If you want to drop something in the comments and let me know about what else you're curious about in the law, especially in criminal cases or the Constitution, drop it there, and sometimes I'll get to those comments and try to make a video that's helpful. I'm criminal defense attorney Ryan Pacyga. You can find me at arrestedmn, like Minnesota.com, or call me at 612-339-5844.